presentation. I'll start with a short presentation on the interaction with the genuine link doctrine, and then we have two presentations by Vikram Chand and Sunil Pancham on the interaction with tax treaties, and the focus is on the UTPR, but of course we might also address some broader questions here of the interaction between Pillar 2 and tax treaties in general. And after Q&A session, we focus on the right to property and the UTPR and potential infringements of bilateral investment treaties. And Irma will close the session with some remarks on EU law and EU tax, good tax governance. So let's start right ahead. We have 2.5 hours time, which is a dense program, but I think that the idea is really to provide you with as much as ideas and information in that regard. We have designed a fact pattern which will follow us through all the presentations today. Just to give you a short background here, we have a multinational enterprise. The ultimate parent entity is in state B, and state B does not know an income inclusion rule, and the UPE owns various subsidiaries in state A. That's at the bottom on the left side, and state A has no QT MTT. We will see in a minute that there is an under taxation in state A. And then we have state C on the right side, and state C has introduced a UTPR. So important for us is there is a UTPR that is applicable, and company X that will face the additional top-up tax here is partly owned by an investor, a resident in state D. That's especially important then for the presentation on bilateral investment treaties. So let's do some number crunching here that we have an actual case. Of course, it's a rather extreme case, but based on extreme cases, I think we can really discuss what the problems are. So we have country A. Again, country A, this is where we have a lot of subsidiaries. There we have an adjusted covered taxes of 1,000. We have global income of 10,000, which leads to a jurisdictional ETR of 10%. So we are undertaxed there based on the model rules. Then if we look at country B, and country B, that is the state where the ultimate parent entity is, there we have a tax rate, an effective tax rate of 20%, so no under taxation, but there is also no income inclusion rule. And then in country C, this is where company X is resident on the right side. There we have adjusted covered taxes of 20 and global income of 100. So we have a tax rate of 20%, so no under taxation. However, there will be a top-up tax due to the application of the UTPR in country C. Now, importantly, the top-up tax will be 500, and that is the delta missing in country A here, so 5% on 10,000. Now, if we do some number crunching here, we realize that this is 5 times the global income of company X and 25 times its adjusted covered tax. Again, it's a rather extreme example, but following the model rules, such situations can happen. So let me start with some remarks on the genuine link doctrine and the potential infringement the UTPR triggers here. Now, what is the genuine link doctrine? The genuine link doctrine is widely accepted, and it says that you need to have a certain link to a jurisdiction in order for that jurisdiction to have prescriptive jurisdiction. And I'm only talking about prescriptive jurisdiction, so the right to regulate a certain fact pattern here. I'm not going to talk about enforcement jurisdiction. Now, there is a wide agreement that something like the genuine link doctrine exists, and I'll try to also discuss its underlying source, its underlying legal source in a minute. There is various case law around the globe, and the only case I will discuss briefly is an Indian Supreme Court decision, which has some important, I think, wording here, which can help us to better understand what the genuine link doctrine is. I'm not going to read the whole part, but only the highlighted sentences here. So I'll start with the sentence in the middle. But certainly no state attempts to exercise jurisdiction over matters, persons, or things with which it has absolutely no concern. And I think this is the agreement currently, that there is no prescriptive jurisdiction if there is absolutely no link to a jurisdiction. Now, it's important to understand why we have such a rule. And here I read again the last sentence of that paragraph here. Such claims i.e. extraterritorial claims, have and invariably lead to shattering of international peace and consequently detrimental to the interests, welfare, and security of the very nation state and its people that the national legislator is charged with responsibility for. So the reason why we are having a genuine link doctrine is that we want to protect sovereignty of states. We want to make sure that states can decide on how they want to regulate their own interest and their own territory here. So let me continue. Now, what is a sufficient link? And now it gets more technical. What is a sufficient link? And here, two comments I think are important. First of all, the link depends on the field of law. So each field of law has developed different links that are considered to be sufficient. And second of all, the extent of jurisdiction depends also on the link that is used. Let me do some examples. Let's start with antitrust law as an example. Here we have an example of a merger of two companies not resident in the European Union, so that's A and B, but the European Union claims that they can apply merger control law as part of their antitrust law. Why? Because the merger will have an effect on the European market. So the link is the effect, and the extent of jurisdiction is that merger control law is applicable. Now, let's use the same example for tax law. And here, probably we would all agree that the same fact pattern is not sufficient to create corporate income tax liability in the European Union. So probably no one of us would claim that the European Union has the right under international law to tax the gain, for instance, out of such merger, if there is any, if there is no physical presence whatsoever in the European Union. So it depends on the field of law, and the extent of the jurisdiction is important. So let me summarize that again. Field of law, define your link, and then you might have different measures, different extent of jurisdiction. So for antitrust law, this means, for instance, that having an effect on a jurisdiction is sufficient for merger control law, but maybe not for predatory pricing abroad. So maybe that's not an area you can regulate, although you have effect as a link. Now, what does that mean for us in tax law? For instance, the source of income, yes, that's a sufficient link, but only to right to tax the income sourced in the territory and not necessarily the right to tax the income sourced in a foreign territory. I think that's really, really important here. Again, field of law and the extent of jurisdiction. Irma, I'm not controlling the chat. If there is any urgent need, just interrupt me. Okay, what is the legal base of such genuine link doctrine? And there we need to distinguish two cases. One is, in some cases, we have an explicit legal base. For instance, interestingly enough, there is a friendship agreement between Germany and the United States. And that agreement contains a rule saying that extraterritorial taxation is prohibited. So kind of a genuine link doctrine, but also constitutions might contain such a clause that you cannot regulate facts that have no link to your own territory. I'm not going to talk about these explicit legal bases today. I'm going to address the situation in which there is no explicit legal base. And here we are mainly talking about customary international law. So we have two options. Either such genuine link doctrine is justified as part of customary international law or as a legal precondition of the international law regime. The second option is a bit challenging to discuss today, and it's probably not the prevailing opinion. So the prevailing opinion is that the genuine link doctrine is based on customary international law. So we have to talk about customary international law also in international tax law, something we have not been used to in the last decades, but it has become a lot more important. So what is customary international law? Well, traditionally, there are two requirements. One is you need to have sufficient state practice, and there needs to be an opinio juris. Now, with respect to sufficient state practice, we will see in the next couple of months how many states will implement a UTPR, how many states will implement Pillar 2 in general. So let's focus on the more challenging one, and that's the opinio juris. Now, what is the opinio juris? The opinio juris is a belief that something is accepted as law. And this is really important. So states follow a certain rule because they think there should be such a rule, and such a rule is accepted as a rule. So it's not just committee, it's really something is accepted as a rule, something is accepted as a law. Now, in our case, we are talking about the UTPR. So the question is whether there is something accepted as law reflecting the functioning of the UTPR. Now, what is the functioning of the UTPR? Well, as we have seen, the functioning works as follows. If you have an entity in a state, that state can tax you on a worldwide base. On a worldwide base, if you belong to a group of companies. So not just your profits, but also the profits of other entities worldwide. And the question is whether this is accepted as law. Now we have a few problems here with respect to the UTPR. First of all, sometimes you have an international agreement that you could derive the opinio juris from. But in our case, there is no agreement. Of course, the OECD mentions that there is an agreement on Pillar 2, but I would challenge that. I mean, it's not a genuine agreement. I have at least not seen a clear document which state representatives agreed on Pillar 2, agreed on what parts of Pillar 2. So we have to be careful here to assume that there is a genuine agreement on Pillar 2. That there is a genuine agreement on Pillar 2 from which we could derive an opinio juris. Second of all, there are a lot of states that will implement a UTPR and have already initiated such process. But is that a sign that states believe that the UTPR is accepted as law? I don't think so. Why? Because many states, such as my own state, Switzerland, will introduce the UTPR because they fear of losing out here in the game, because otherwise other states will tax the income, not because they believe such a rule should exist, but because they have a fear that they will lose part of their revenue base. That's the second important part. The third important part, and talking to international lawyers, I have realized that over the past weeks, it's all about reactions. It's all about reactions. So that means that when you have a question of whether there is an opinio juris, you have to understand how other states react. And we will see in the next couple of weeks and months how will states react to the implementation of Pillar 2. Of course, we have now some indications from the US that the Republicans are not happy with the proposal and they will publicly oppose it potentially. And in other states, we might also have such reactions. And I think that is my personal recommendation to states that are unable or unwilling to implement Pillar 2, that they publicly oppose it. And then you can ensure that you're not bound by customary international law. And I think that's really important. So if you're unable to implement Pillar 2 or unwilling to implement Pillar 2, you should publicly oppose it in order not to be bound by international customary law. Even if you implement, you can still do that, because maybe the reason why you're implementing it is because, again, you have the fear of losing out here in the game. But that's my personal recommendation. Of course, we can debate about that. So what are my conclusions here? And again, what are we talking about? We are talking about state C here. Has state C the right to apply the UTPR, or does state C infringe the genuine link doctrine? First of all, I think it's important that there is a lowest common denominator, and that is that there should be no jurisdiction if there is no link. Now, in our case, of course, there is a link, right? We have a link, we have an entity which is resident in a state, or a PE that is in a state. However, whether a link is sufficient depends on the extent of jurisdiction, as I have mentioned, and the normative justification. Why are we doing it? The problem with Pillar 2, and especially with the UTPR, is that the extent of the UTPR is rather extreme. What do I mean by that? It's not about source taxation, it's really worldwide taxation. So the extent of the link used here will be rather extreme. Moreover, the link can be very minimal. So for instance, a hotel room can be sufficient to, renting a hotel room can be sufficient to create a permanent establishment, and having a permanent establishment in a jurisdiction might be sufficient for the UTPR to kick in. So on one hand, we have a minimal, a very small link, and we have quite an extensive consequence, which is worldwide taxation. Now, what is the normative justification? Because again, as mentioned, it's all about normative justification. Why are we doing it? Why are we doing it? Now, of course, we can say it's about anti-abuse, but I think Pillar 2 goes far beyond anti-abuse, and that is, you know, the common agreement. There is a common agreement about that. So it's about harmonizing competition. But is this something we could justify by a global rationale? Because that could help us. If there is a global rationale, a global justification for the UTPR, then it would be a lot easier to argue that it has become a part of customary international law. For example, a minimum tax on CO2 emissions. There, I think I could argue that this is justified. This is in line with customary international law, because the normative justification is, well, it's good for all of us, right? It has a global purpose, so therefore we can have jurisdiction from a global perspective. But with respect to the UTPR, it's a lot more difficult. My personal opinion, again, my personal opinion is that the UTPR seems to be contrary to international law. It's really a rather extreme measure here. And, you know, as I have already mentioned, I think states that are unwilling or unable to implement Pillar 2 should publicly oppose it, not to be bound by it through customary international law. Now, we should be careful here what we wish for, because I think we see a fundamental change now with the UTPR. And then I hand over to Vikram. Why? Well, the OECD and the United Nations have been very successful over the past decade to build up a rather stable system. And the stable system depended on the element of residency and the element of source. And the extent of jurisdiction was different with respect to residency and with respect to source. But now, by introducing the UTPR, we are questioning the whole system. We are questioning the whole system that has stabilized international cooperation in the tax area. And this is exactly why we need international law, because international law can help to develop limits of such a development. Because what will happen after Pillar 2? Well, the Pandora's box is open, right? If you assume that there will be a minimum tax on individuals, well, then we could apply the same logic, and every state would have a taxing right to tax foreign residents if they own any asset in your state. And I think this is not the way we want to proceed, because it creates just a lot of risks, it creates just a lot of uncertainty. And I think this is why it is important over the next couple of weeks and months that customary international law develops again in the international tax field. And my personal opinion is that the UTPR is too far reaching. And maybe the IRR isn't, but the UTPR, its effects are just very extreme. And we see that already, that a lot of states, also developing states, have to change their domestic tax law because other states apply the UTPR. And that's exactly the situation where we have an infringement of fiscal determination. You are not anymore allowed to do what you want, but you have to follow what other states do. And this is why I think we need to have an open debate about that. Having said that, I think I'm at the end of my presentation. We take Q&As after Vikram's and Sunil's presentation. And if that is fine for everyone, I hand over to Vikram. Many thanks.
So thank you, Peter, for that wonderful presentation. Indeed, there are many conflicts between the UTPR. Can you hear me? Sorry. Yeah, sorry, there was an echo. So yes, thank you, Peter, for this wonderful presentation. Indeed, there are many, even after listening to your presentation, and I really think that there are challenges between the UTPR's implementation of the national law and basically international law. So you see, but the issue with discussing the compatibility between the Pillar 2 rules with international law rules is that the boundaries of international law are not properly defined. So the genuine link doctrine is a bit open-ended. Arguments can be made for and against. So the point here is that because the boundaries of international law are not properly defined, it gets we are entering into a highly challenging space, and we're trying to ask very difficult questions. And you've made an excellent presentation, and somehow I'm sort of agree with your conclusions. But moving away from moving away from international law, where things are a bit open-ended and subjective, let's move to hard law. And tax treaty law for me is hard law. And in my presentation, I'm just going to discuss the interaction between the globe rules with tax treaties. Just to pick up on one of the examples which Peter discussed, I just have my own little version here. In this example, we have a UP in country R, and it has a subco in country S, as well as a P in country S. The subco 1 and P, they have an effective tax rate of, let's say, 10%. So they are low tax. So now the top-up tax can be picked up by the country of the UPE, that is country R, or it can be picked up by the country of subco, which has enacted the UTPR. Just a few words on the income inclusion rule. When you're dealing with the income inclusion rule itself, I just wanted to mention to you that there could be potential conflicts with tax treaties. Actually, I've written a paper with Alessandro Turina and Kinga Romanovska from our center on tax treaty obstacles on Pillar 2 implementation. It was published in the World Tax Journal of the IBFD. So whatever I'm saying it on behalf of our authors, as well as whatever we are saying, I'm saying right now is there already in the paper. So if someone's interested in that, they can read the paper. With respect to the IIR, one of the conflict areas which we've identified was actually the arm's length principle, Article 9.1. Because these rules apply only to related enterprises, the globe rules. So, we've put arguments for and against without getting into the details. One potential area of conflict is with Article 9.1 itself, because Article 9.1 talks about the arm's length principle. These rules apply only to associated enterprises, or in majority of the situations, only to related parties, the globe rules, the IIR or the UTPR. So we've put across an argument in our paper that there's a potential infringement with Article 9.1, which we agree it's debatable, but that's a challenge there. What we have also said is that potentially the income inclusion rule also conflicts with Article 7.1. And we have actually said this because of our research with respect to the interaction of CFC rules with tax treaties. With respect to interaction of CFC rules with tax treaties, the OECD's position is clear. The UN position is clear. They basically say CFC rules don't conflict with tax treaties, whereas some courts, a lot of courts have agreed with that position. On the other hand, there are dissenting opinions too among academics and dissenting opinions among courts also. Some courts have actually said CFC rules conflict with tax treaties. So if you go ahead with that logic, then the IIR also conflicts with tax treaties, because in our particular example, subco 1 will not have a P in country R, but still the UP is going to apply the IIR to it and tax the income, in the sense that it's going to collect the top-up tax. That's another area where another area which we've identified is also Article 10.5, which deals with prohibition of extraterritorial taxation. Now, in Peter, in your presentation, you had spoken about the GVK industry case. Well, actually, I met the GVK industry case. The person, the owner of the company is Mr. GV Krishna Reddy. He's from Hyderabad, from the same city I am, and I had the chance to meet him. But unfortunately, I didn't discuss the UTPR with him. So just to let you know, so on Article 10.5.2, and 10.5, which deals with prohibition of extraterritorial taxation with respect to dividends. Actually, there's something there in the treaty, in the OECD model, which somehow crystallizes the genuine link doctrine. Because Peter, you had mentioned in your slides about the US-German Friendship Treaty. Here in tax treaties, there's a clear provision, Article 10.5, which basically tells countries, sorry, you're not allowed to engage in extraterritorial taxation of dividends. And I think Article 10.5, which is a highly unexplored article in tax treaties, can actually be used here to basically say that IIR or UTPR, especially the UTPR, conflicts with tax treaties, because UTPR is actually, picking up the top-up taxes from another country. We can discuss that. But, another potential conflict is with Article 10.5 with respect to the IIR. With respect to permanent establishments, it's obviously clear, many countries in the tax treaty policy, they follow the exemption method. So for example, if you have a country which has a treaty with Mauritius, for example, and profits attributable to the Mauritian PE are exempt in the home jurisdiction because the treaty contains Article 23A of the OECD model, contains the exemption method. Well, in that particular situation, if you now start saying that the country of the headquarters can start collecting top-up taxes for a low tax fee, even though the treaty says you follow the exemption method, of course, there's a conflict. There's an obvious conflict. Actually, the OECD recognized that there is a conflict in this area, and the proposed states that probably they will design a switchover rule and try to find a solution to this particular matter. At the same time, without getting too much into details, some conflicts can also arise with tax-sparing clauses. Typically, tax-sparing clauses exist between developed and developing countries in treaties between developed and developing countries. So possibly you can also say that in certain situations, conflicts arise with the tax-sparing clauses. Now, moving to the UTPR, which we are going to talk about, which we are supposed to talk about a lot today. Well, my position is very clear on that. It's expressed in our paper. The UTPR for us also conflicts with tax treaties. Well, there are potential infringements between the UTPR with the arm's length principle, which is in Article 9.1, with Article 7.1, which deals with taxation of undistributed profits. Article 7.1, which deals with taxation of business profits, and Article 10.5, which deals with taxation of undistributed profits of a particular company. Less conflicts with the non-discrimination provisions. Why? Because the way the rule is now being designed, the UTPR, it can actually deny a deduction for a payment if it's even made cross-border or even domestically. So the non-discrimination, somehow the conflict with the non-discrimination rules have been minimized. But still, I believe conflicts can arise with Article 9.1, 7.1, and 10.5. The question is, does the saving clause help? Now, the saving clause is a clause which you typically find in US tax treaty practice. This clause is not there in all the tax treaties which countries have concluded with one another. It's there in the US treaty practice. Well, but still, and what does the saving clause do? Basically, it permits the residence countries of the taxpayers to tax their own residents on an unlimited basis. But in our paper, if as probably some of you who will be interested in reading that, we basically argue that some provisions can be imported into the saving clause, into the exceptions list of the saving clause, because the saving clause does not provide for, does not list Article 9, basically it lists Article 9.1, but what we're trying to say is we're trying to import Article 9.1 into the list of savings clause. Why do we import that? Because in the non-discrimination provisions, the OECD already had created precedents of importing Article 9.1 and Article 24.5, which deals with ownership non-discrimination. We also use that logic and we try to import Article 9.1 into the list of exceptions to the saving clause, with the effect that possible infringements would also arise with the arm's length principle. That's something unique that we came up with in this paper, which is also open for debate. So to cut a long story short, my personal view is that the possibility of frictions between the IIR as well as the UTPR with tax treaties, well, there's clearly there's a lot of room to argue that disputes, conflicts arise between IIR and treaty law, as well as UTPR and treaty law. UTPR more than the IIR, because for IIR at least there is precedence with respect to the interaction between CFC rules and treaties, where some states have basically said CFC rules are compatible with treaties. Even courts of some countries have said that. So even though the chances are lower with respect to IIR, based on existing case law, I would still say there is a conflict, and we've expressed that opinion already. And with respect to UTPR, it's obvious for me. I don't know why people are just closing their eyes and saying there's no conflict with treaties. Of course, there's a conflict with treaties. And if a state decides to introduce a UTPR or the IAR in the national law, I personally feel that that basically leads to a treaty override. And the question then is, how do you deal with treaty overrides? Well, actually, if you think about it, treaty overrides, when you have a dispute with respect to treaty overrides, of course, you can follow the domestic litigation path, but perhaps even states can agree with each other on how to resolve that issue through a mutual agreement procedure, because we are talking about a tax treaty issue at stake here, the interaction of domestic law with treaty law, and we are trying to say that there is a treaty issue. So basically, perhaps countries can apply Article 25(1) to resolve this at the treaty level itself, some issues, so that power is there with the competent authorities. Whereas the question also arises is whether countries can challenge all these treaty overrides, national law treaty overrides through bilateral investment treaties. Of course, they can. Obviously, they can invoke bilateral investment treaties, and they can say, to the extent it applies, they have no tax carve-outs. That's the exception, and they can actually challenge these kind of issues, these treaty override issues under bilateral investment treaties. So, because I personally feel that there are treaty conflicts with treaties, and possibly, that's not the benefit of the work that is being done by the OECD. There are clearly conflicts with treaties. So, in our paper, we've proposed that all countries basically sign up to a safeguard clause, which will possibly come up in a multilateral convention. We've been proponents of opening a multilateral convention so that there's a proper treaty among countries where they basically, all the treaty partners, they agree in writing. We subscribe to the OECD rules, which is the IAR, UTPR, as well as the QD-MTTs. And in this treaty, in addition to listing a lot of other things, they can also list the compatibility between between these globe rules, which will be introduced in national law and treaty law. And we've proposed a safeguard clause, which can be included in this treaty. The safeguard clause will basically function in such a manner that they would authorize countries to implement these globe rules in the national law. So to cut a long story short, the only way forward, which I feel a sustainable way forward, is that a multilateral convention is open. And in this multilateral convention, states agree clearly. It's not a political agreement, a proper agreement like the MLI, but not really the MLI, because this is, let's say it's like the Pillar 1 Amount A treaty. Pillar 1 Amount A kind of multilateral treaty needs to be open even for Pillar 2, where states sign up to this and they agree on a lot of things. In addition, one of the points they can agree to is on the compatibility between national law and treaty law. And essentially, by doing that, they can include a safeguard clause, which will authorize states to apply these rules. Well, what is the advantage if they do that? Well, then, we will not be having these discussions anymore, I guess, on compatibility between national law and treaty law. The chances of frictions with treaty law just diminish. Possibly chances of frictions with bilateral investment treaties may also diminish to a certain extent. But this also needs to be looked into a bit more in detail of how a multilateral, if the OECD decides to open a multilateral convention, include a safeguard clause in that, till what extent can bilateral investment treaties still be invoked to basically tell countries that you still cannot apply the globe rules. I think the chances go down quite a bit if that route is followed, but let's see what happens. So with that, I hand it back to you, Irma, for further questions or debates or whatever you want to do.
Thank you so much, Vikram. We will give now the word to Sunil. And then after Sunil, we will have 10 minutes for questions. But please feel free to still raise your questions in the chat. And then after I will take some of the questions. So we'll give the word to Sunil, and perhaps because there are different views between Vikram and Sunil, we can also give perhaps 2 or 3 minutes more to you, Vikram, to also react to Sunil's presentation. So let's go ahead with UTPR and international customary law, a Dutch perspective. And I have invited Sunil because we know each other, but also there are, what I mentioned, there are different views, and that's what also important to present here. Sunil, please go ahead.
Thank you, Irma. Thank you, Peter and Vikram for your views. Very interesting, and basically I agree with your views, but I have a slightly different view on some aspects of the application of the UTPR. And I have 10 minutes, I believe. I was invited by Irma 2 days ago, I believe. It was quite challenging to draft a presentation. So let's see what we can do. First of all, I will briefly address 2 questions. First question is, the UTPR, is the UTPR actually a CFC rule from a customary law perspective? I will not discuss the income inclusion rule in detail. And if so, is the UTPR compatible with tax treaties from a customary law perspective? So my starting point is Article 7, paragraph 1 of the OECD model. The text of this provision does not provide clear nexus rule or a link rule. So that would mean that in this structure, state A would be able to tax the profit of subco. But it is submitted by numerous authors that this would conflict with the customary law nexus principle, which I call the main nexus principle. And actually the research paper of Vikram was published in 2022, I believe, with 2 other academics, addresses this issue. And I fully agree that there may be a conflict when we assess the UTPR against the main nexus principle. But still, as an exemption, is there maybe a special CFC nexus principle in customary law? And apologies, stating that CFC rules are compatible with tax treaties. So, as Peter already discussed, in order to create customary law, there are 2 main conditions, actually state practice and opinion of jurists. Peter has discussed these two conditions. And as regards state practice, one could say that regarding CFC rules and their effectiveness under tax treaties, there are a lot of countries, sufficient number of countries actually for purposes of customary law that apply such principle. And it's all about practice under customary law. So there is a state practice, I think, which essentially boils down to a principle, which I call the special CFC nexus principle. And even if a limited number of states embraces such principle, still the customary law may exist. That would be a limited, what I call a limited customary law. It's called particular customary law. It still may exist. And in a paper of the Belva and the Blue, it is stated that the majority of case law endorses the OECD view on the compatibility of CFC rules with tax treaties. So there are arguments to say that there is a state practice under international law. The second condition, opinion juris, Peter explained that state must feel that it has a right to act so. In this concept to apply this special CFC nexus principle. I believe that's the case, given the case law and given the sufficient number of countries applying such rule. Opinion juris is about, it's something psychological. You have to assess what a state think. That's very difficult, I believe. But given the state practice, one could say, well, there is an opinion juris. So one may conclude that CFC taxation and its effectiveness under tax treaties can be based on customary international law. So there may be a special CFC nexus principle present. So what would that mean for the UTPR? Well, let's focus on the basic of CFC rules. The policy objectives of CFC rules are rather clear, I think. It's prevent from shifting income to lower tax countries. I'm aware of the fact that there are different underlying objectives, and it interacts with notions like capital import and export neutrality, the exemption matters under tax treaties. But the basic idea is of CFC rule in different countries to prevent shifting of profits to lower tax countries. And when we look at the design of CFC rules, what can we see? The base case is in this structure that company A would be subject to CFC taxation because it's a shareholder of this CFC entity. And the basic design is often that there is a direct or indirect shareholding connection. But there are also other connection factors, such as control. What we see in this picture is that entity C has control in respect of the CFC, or maybe is company C entitled to certain profits of CFC based on a, let's say, profit participating loan. In some countries, CFC rules are applied at the level of company C. And also, company B is an indirect sister company. Sometimes CFC rules are applied. For instance, in the Netherlands, under certain circumstances, entity B, resident of the Netherlands, may be required to apply CFC, the Dutch CFC rules on the CFC company, not directly owned by B, but by sister company A. So what we see is a wide variety in design when it comes to the connecting factor under the CFC rules. And some countries have CFC rules not only taxing passive income, but also active income and business income. So, the third relevant aspect of CFC rules is that some countries have CFC rules that subject CFCs to CFC rules, even if the CFC entity is high tax. So the question here is, when it comes to the design, is there a semblance to the UTPR for customary law purposes? Are CFC rules comparable to UTPR when it comes to the design of the rules? That's the first question. And this is important for customary international law because it is often stated that these rules are not comparable when it comes to design. But I disagree with that. So there is a certain resemblance, I would say. But the next, and I think important questions for customary law purposes, is whether the objectives of both sets of rules are the same. So I've mentioned briefly the objective, the general objective of CFC rule in most of the countries. And what is the objective of the top-up tax, in particular the UTPR? Yeah, that's clear for everyone, I think. It's to ensure that companies are paying a minimum level of tax. And from a customary law perspective, is that not the same as under the CFC rules? That's the question. So there may be also a resemblance regarding the objectives of both rules. So finally, the question is the UTPR effective under the tax treaties given the possible resemblance to CFC rules when it comes to design and the objectives? And is there a special CFC nexus principle under customary law? And if that would be the case, and if there is sufficient resemblance, one could say there is a right for states to apply the UTPR under tax treaties without violating the tax treaties. Thank you.
Thank you so much, Sunil. There is a lot of questions in the in the chat. I'm trying to follow up on the questions because there are also people replying in the chat to the questions. So, but I want to still give, because I want to give just 2 minutes to Vikram, perhaps to react to Sunil, because I know I was the one who invited Sunil, but I think that both of you are amazing scholars and also know a lot about the topic. So perhaps Vikram, are CFC similar to UTPR? That's a very straightforward question.
Well, the straightforward answer is no. It's not very similar to. I mean, the IAR is not similar to CFC rules. That's the straightforward answer. But I know views differ on this, and actually it's very nice, Irma, that you're having a debate and where you actually invite people with different views. And this is what's really missing at the international scene, where the debate is just pro OECD. So pro OECD work by other international organizations without naming them. But it's good that we have this debate and where you have a difference of views expressed. So yes, my clear answer to that is the CFC rules are, I mean, the IIR is not similar to CFC. The objectives are different, the purposes are different. And actually, IIR is essentially a rule to prevent anti-tax competition, as said by Professor Luc Debroux in one of his speeches, which I attended recently. And you know, CFC rules is to counter more abusive stuff or shell stuff, you know, and it's like an anti-avoidance rule, the CFC. But IIR goes beyond that. The purpose of the IIR is beyond that. So I would say they're different. And at the same time, the UTPR is one of the most craziest rules of international tax law ever invented. And for me, that's just obvious. It's extraterritorial taxation. And there's a clear infringement with tax treaties. So you know, people can say, well, we're taxing our own country's residents, so we can do whatever. So basically that means that tomorrow the Swiss government can just come to me and they say, well, you know, Peter and me, we live in Switzerland, so the Swiss government can enact a rule saying, Mr. Chand, you live in Switzerland, you know, you are of Indian origin. Boom, we taxed you double than what Peter pays. Like, what? It doesn't make any sense. And then possibly, you know, and I read one of the articles, I think it was from Jefferson Vanderwalk, and he gave a wonderful example. So like, for example, I live in Switzerland. If my cousin lives in Australia and suddenly I'm being taxed in Switzerland, my cousin, the income which my cousin derives in Australia, completely senseless. It's senseless. It doesn't make any sense. So, you know, it's good that we're having this debate. My personal view is, you know, in views differ on this, but my view is that there is a infringement with treaty law, and treaty law is hard law. We're talking about tax treaty law, which is hard law. International law is still a bit in the air, you know, that's my view. It's very subjective, international law, but I don't want to interfere into that discussion. But here with hard law, clearly infringements arise. My personal view. Sorry for that.
Thank you so much, Vikram. But I do have to give 1 minute more to Sunil, and then I go to 3 questions. Okay. I identified 3 questions. Sunil, I have to give you.
I appreciate it, Vikram. I'm aware of the debate, and sometimes it sounds crazy that there may be taxing arise on the tax treaties when it comes to the UTPR, but I have addressed the customary law perspective, and sometimes it's also hard law. I understand what you mean by it's more in the air, but it's also hard law, and it should be applied. And the key question is whether, from an international law perspective, actually customary law perspective, whether there is a principle, just like for the CFC rules and their effectiveness on the tax treaties. That's the key question, I think. And there are different opinions, but again, and as you expressed already, it's good that we have a debate on that.
Thank you so much. Vikram?
Yes, just one follow-up question, actually. So when we argue that UTPR or IIR conflict with international law, what's the end game here? Where can we actually go? Which court can we go to and make this argument? That's my question for Peter and to Sunil. Where can you go defend this position that, you know, there is a breach of international law? Realistically, which courts, what avenues are there? And, you know, is it a realistic option when we argue that UTPR or IR breach international law? Where can we go defend this position? That's just a very simple question. Simple question, yeah.
Let me direct that question to Peter. So Peter,
Yes,
that
thank
question,
you.
and you have other questions that you can reply, but I think that is important, the question of Vikram.
Yes, and first of all, thanks for all our distinguished colleagues. I'm very happy that you all joined, a lot of friends also. We try to address as many questions as possible, but it's very difficult, but the debate is amazing. Now, with respect to that question first, Irma, I think Vikram, it depends on your domestic system. So, for instance, in my country, Switzerland, you can address infringements of international law in general at the court level. And, you know, customer international law is one source of international law. So potentially you can say your domestic act infringes customer international law. Now, for instance, what you see in Germany, and maybe Matthias Walter can comment if I'm wrong, Germany is a dualistic country. And what they did in their implementation law is they said the domestic implementation law prevails over tax treaty obligations. And they can do that because it's a dualistic country. But in the German Act, they did not mention, for instance, the friendship agreement or customer international law. So I would be happy to hear anyone from Germany how they will address that. But short answer, it depends on your jurisdiction. In my jurisdiction, you could really argue that this is an infringement of customer international law. And I think that's the way forward. And I think we will see these cases. And that they will happen. Now, one comment, if you allow, to Sunil's presentation. He said that, you know, it's difficult to assess what a state thinks. And I mean, I fully agree with you, Sunil. This is why I raised the fact that it all depends on reactions, right? And we would all agree that we are right now in a very dynamic environment. As mentioned, the OECD questions a system that has worked for decades by implementing the UTPR. So we need to find a new level playing field potentially if this goes as people think it goes. And then we need to look at reactions. And reactions is, you know, public statements by official that this is too far reaching, public statements by representatives that this is too far reaching. We need to stop the extraterritorial effect at one point. And otherwise, again, I think that's the Pandora's box. I mean, we will have the same debate on individuals. Well, if you have a cousin, and yes, the example is extreme, but it shows how extreme the UTPR is. If you have a cousin in Australia and your lump sum tax in Italy, or you are a non-dom in the UK, well, we are going to tax you on a worldwide basis because you're undertaxed. I mean, this is the consequence. And I really fear that, you know, when we implement Pillar 2, that we risk that our whole traditional, very stable system of tax treaties and the distinction between residence and source will collapse, and that's my personal fear. Now, I think one question of Jérôme that I can address, you know, and the dynamics of customer international law. I mean, you're fully right. There is a dynamic. So potentially, if no state reacts, this is going to be the new customary rule that the UTPR state has the right to tax worldwide income. Well, fair. if this is going to happen, I agree. There might be dynamic developments. Irma, I hand back to you.
Thank you, Peter. Thank you.
Thank you so much. Let me, because there was a question on customer international law from Jerome Montenegro that also Philip has addressed it a little in the chat, but I think it is very relevant. So let me give the word to Jerome, and then after I will give the word to Vikram. Is that okay?
Well, I've already, thank you, Irma. I've already asked my question, and Peter commented on it. Okay,
then it's okay because okay, so let me go back to Vikram, and then after I will perhaps ask Dieter Bettens to ask his question because he has also some questions. Vikram, please go ahead.
Yes, just on the international law side, I just wanted to also mention, you know, when we talk about tax law rules, like for example, you take the arm's length principle. The arm's length principle is in the national tax law of how many, or more than 100 countries right now in the form of transfer pricing rules. The question I ask myself sometimes is the arm's length principle a customary rule of international law, or is it a general rule of general principle of international law? And somehow, you know, for both the questions, somehow I'm coming to the conclusion it is not. It is not a customary rule because there are so many differences in how it's applied, the arm's length principle. Definitely not a general principle of law. You know, when I think of general principles, I think of legality, proportionality, and all this kind of stuff. But the arm's length principle, can you say it's a general rule of law, or is it a customary international law rule? I personally think no, even though it's been implemented in 110 countries. The UTPR so far is going to be implemented in what, you know, if you count the European countries and some common law countries, probably 35, 40 countries so far. How could you just say it's customary international law? So, you know, there also, I'm just trying to, you know, get my head around the international law debate, because I still don't think it is international law, it's customary in nature. For example, just one point, you know, in Sunil's presentation, I think he had mentioned a paper of Luke and Philip. Well, basically in their paper also, they had clearly mentioned that the IR and UTPR were in fact not comparable to CFC rules, but I just wanted to make this point clear. So
yeah, sure. I've read that excellent paper of Philip and Luc de Broe, but I disagree with that position. So that's what it's all about. We have a debate on that.
surely.
Because I see a similarity with the CFC rule and the understanding of CFC rule on the tax treaties and how it is applied in a serious number of countries. I think CFC effectiveness on the tax treaties is part of special customary law, and subsequently, given the similarities between the UTPR, IR, I would say taxation under such rules would be also part of customary law.
Yep. So yeah, just on the customary side of things, you know, ALP itself is not customary in nature, at least in my view, at least in my thinking of customary international law. How can the UTPR be customary international law? It cannot be in the customary international law.
The first step is actually, is it similar, or at least comparable with the basics of the CFC rules? That's the starting point. And if you take the step, and in my opinion, it's quite comparable from a customary law perspective, given the conditions to create a customary law.
Thank you so much. I think that we work on a special issue with Julian Chase, where we discussed the interlink between international public law, international tax law. And one of the things that we also see there is need for more research on that. And one of also the things we see is that there are different perspectives, and perhaps Julian will want to comment a little on that, but I don't want to put you on the spot. But Peter has a comment. The only thing when I always think about international customary international law is that be careful what you wish for, because if you are saying that international customary international law, that it is customary international law, that there is a state practice opinion jurist, then you may have create a bigger problem. And that's something that I learned when I was doing this article on the principal purpose test, that it was quite difficult to still say there are approximations, but not yet. So, but I give the word to Peter, and perhaps if Julian want to react, and then we will close this part of Q&A. And then after I will give, we will take the time. Okay, Peter, please go ahead.
Yes, one thing, if we compare CFC rules to the UTPR rules, and you know, with respect to CFC rules, Ruben Aviona argued several years ago that it has become part of customary international law. But you should not forget that the reactions triggered by CFC rules by other states are very different than with respect to the UTPR. Because first of all, CFC rules are not as strict as the UTPR. You know, often they contain exceptions for non-abusive situations, etc. That's one important difference. The second important difference of CFC rules is you apply your local tax law in the parent state in order to determine whether you're undertaxed. Now, what we see under the model rules is that we have a harmonized standard, in particular with respect to tax credits. And this is, I mean, it's crazy what's going on now. We are forcing now all states around the world to change their incentive schemes, right? And that shows you that the impact the UTPR has on incentive schemes is a lot different than the impact of CFC rules. And this is why I would be reluctant to compare the two. And this is why I also expect different reactions. Maybe states have been quiet with respect to CFC rules because the impact is just less intense. But now I think we will see a lot of reactions by states saying, well, but this is rather far-fetching. I have to change my entire tax system, my incentive system within 3 months. And so I think that's an important difference. Thank you, Jan.
So I just want to react on that. I fully disagree with that position from a customer law perspective. So what we are doing here is try to find the differences. But if we look at the case law of the International Court of Justice or and other international courts, generally the courts try to find similarities between rules. And Peter, you discussed those two criteria of customary law, the two conditions. And important is whether there is sufficient similarity between the UTPR and the CFC. And we are all aware that there is a debate going on, but to my opinion, key is that there is sufficient similarity in order to say there is a state practice and opinion juris on the CFC and subsequently for the IR and the UTPR.
Thank you so much. We have still 3 minutes before the next presentation because we have this Q&A, but perhaps it would be nice just to have 2 very quick minutes for people who just do something. So like kind of, so we will be back in 3 minutes. We just wait 1 minute, 1 second to the people to start joining. But for Peter, there is still time after these 2 presentations to address some of the questions. And perhaps if Dieter Bettens would like also to ask that question after the 2 presentations. And so after these 2 presentations from Philip de Belba and Julian Chase, we will still have half an hour to discuss some of the questions that had been asked from the previous speakers, as well as the questions from Philip and from Julian. So, Philip, please go ahead.
Thank you so much, Irma. Hello, everyone. It's, I think, time to add another angle to the debate, this time the angle of human rights, and more specifically, I think the right to property as included in the European Convention on Human Rights. Now, perhaps by way of introduction, because not everyone might be familiar with the provision as such, the right to property as included in the European Convention is quite a strange provision, and it has a strange relation to taxes, let's say. It is in fact the only provision in the European Convention that mentions the word tax, and it does so in a negative way. It basically says, well, everyone is entitled to peaceful enjoyment of his possessions, but this does not prevent the state from levying taxes. It's very important to note here that the provision not only applies to natural persons, but also to legal persons. So also companies can invoke the protection that is provided by the right to property. Now, that second paragraph of the provision saying that, well, the state has the right to secure the payment of taxes is called the so-called tax carve-out provision of the right to property. And some authors have argued on the basis of this provision that the provision does not capture tax measures as such. But in fact, the European Court of Justice has developed its case law in a period of over 60 years. And everyone agrees that currently tax measures are in fact covered by the provision as such. And there are really dozens of tax cases dealing with both substantive and procedural tax measures. In fact, the European Court of Human Rights has stated that every tax is a prima facie infringement of the right to property that can, of course, be justified according to the court's triple test. In short, there needs to be a legal basis for a tax, the so-called lawfulness criterion. This is not merely a formal requirement, but also requires that the tax measure is sufficiently foreseeable, precise, that the legal basis has a certain quality. Second, the measure needs to be taken in the public interest. This condition is easily fulfilled. In fact, European Court accepts a wide variety of public interest grounds, such as the need to conduct financial and monetary reforms, the need to counter tax avoidance and so on. So this is a really light test. I think there's only one case, one tax case in which the court decided that the public interest ground was not fulfilled. And thirdly, the tax measure needs to be proportional. It needs to strike a fair balance between the impact on the taxpayer and the general interest. The court often uses the test that the taxpayer in question cannot have an individual and excessive burden imposed upon him. Now, it's important that all of these three conditions need to be fulfilled. If a tax measure does not pass, for example, the lawfulness criterion, well, then a violation of the right to property will take place, and then the proportionality test is no longer relevant. The main focus of the first part of my presentation will be the proportionality test, the fair balance test, as applied to the UTPR, the tax imposed upon the taxpayer as such. And afterwards, I'll have some other comments regarding the so-called lawfulness test. So what I've seen throughout my research is that in order to assess whether a measure, including a tax measure, infringes the right to property, the courts even look at several criteria, several elements that can lead to a violation of the right to property. I will go through some of these criteria, and I'll start with probably an easy one, legal certainty or legal uncertainty. The question is, does the taxpayer have a certain amount of legal certainty? Are the actions that he takes clear to him, or are the tax consequences of his actions clear? Now, this test, the legal certainty test, is comprised of several sub-tests, including the question whether the tax legislation in question is clear, is it well written, is it available to the taxpayer, and if yes, under what form? So this requirement only looks at the existence of the legal base, but also the quality thereof. Now, I think everyone here can agree, otherwise we wouldn't be having this discussion, that the rules on Pillar 2 are extremely complex. If you count the number of pages you need to dig through, we have 70 pages of rules, 228 pages of commentaries, 49 pages of examples, excluding documents such as the administrative guidance of 111 pages, the safe harbors and penalty relief guidance, 30 pages, and so on. So these rules are complex, and yeah, they still leave much to the imagination of the taxpayer. Much is still unclear. Second question is, well, even if we suppose that the rules are clear, the effects of these rules also need to be clear. The taxpayer must have a certain amount of foreseeability of the effects of these rules on his tax position. And also here we notice that the rules currently leave some gaps. For example, who should pay, which entity should pay the tax within the UTPR jurisdiction? It's also a question whether the taxpayer in the UTPR jurisdiction can in fact know the amount of taxes that are paid by the low taxed constituent entity. So the mere fact that he is being taxed is unclear. This can lead to a situation which is called by the European Court of Human Rights, a situation of chronic uncertainty. The taxpayer does not know what the outcome of his legal actions. Now, it should be mentioned here that the court conducts a very subjective analysis. It means that the court looks at basically the ability to pay of the person involved, the taxpayer involved, and also whether the taxpayer has access to legal advisors, lawyers, attorneys who can explain the legislation to the taxpayer. So one could argue that an M&E group does have access to such persons, so it will be hard to find a violation solely based upon this ground. Next up is the question whether the tax measures, so the UTPR, discriminates in one way or the other. Now, here you need to combine the right to property with Article 14 of the European Convention on Human Rights. That article does not have an autonomous existence, and it merely complements the other rights contained within the European Convention. It essentially means that the article cannot be taken on a standalone basis, but needs to be read in conjunction with, for example, the right to property. This article basically says that for an issue to arise with regard to discrimination, there must be a difference in treatment of persons in relevantly similar situations. Again, here we can ask some questions regarding the UTPR. For example, the mere fact that the UTPR is imposed upon one entity and not on other group entities in the same jurisdiction, is that a problem? Or the mere fact that UTPR is imposed upon one entity, is that entity compared to other entities who are not subject to globe rules? Because there will be a difference in the tax burden imposed upon the entity itself. Again, here the court takes a very subjective approach. It gives a wide margin of appreciation to countries, and the court basically says, well, systems of taxation, and I quote, inevitably differentiate between groups of taxpayers, and the implementation of any taxation system creates marginal situations. So there is a wide, let's say, margin of appreciation here for states, but still one can wonder whether the UTPR rules do not go beyond what is reasonable, let's say. Next up, and this is of course an important test in the area of taxation, the question whether the tax burden of the taxpayer is too high. This is the quantitative test. And of course, the higher the tax burden, the more likely a violation of the right to property will occur. However, I really want to emphasize that this is only one of the relevant factors. Even if the quantitative tax burden is quite low, the violation of the right to property can further be deepened by other criteria, such as on the basis of discrimination or legal certainty, for example. Now, if you look at the UTPR itself, the tax of 15%, let's say, is quite low, but the problem lies in the fact that it's calculated, as in Peter's example, on the low tax entity's profits, and it's imposed on the entity that is subject to the UTPR. I have called this the UTPR in the absence of a decent definition in the rules. Other relevant criteria here are the fact that, for example, whether the taxpayer has other assets left after the imposition of the tax, where the tax measure was adopted rapidly without sufficient time to adjust. The Court of Human Rights has on multiple occasions said, well, in case a person needs to sell assets in order to comply with governmental duties, such as payment of taxes, there is a problem. Does the taxpayer have other means of subsistence at his disposal? Sorry. Does he have other assets? Can he still continue his business? Can he continue his activities? Those are all relevant questions that one can ask. Again, the court will look at the status of the taxpayer as a whole, will look at his qualification, for example, as an MNE. But it is important to keep in mind that the court will look, in my opinion, at the taxpayer at an individual level. The court will generally not assess the status of the group, the means that the group has at its disposal. So the court will generally not pierce the corporate veil, unless, of course, there is a situation of abuse. And then we can return to the discussion that Vikram and Peter had a couple of minutes ago. Now, to make a conclusion here, I think that the court will take a holistic approach, will take all relevant elements into account, but I think one cannot deny that there are several criteria that could point towards a violation of the right to property merely on the basis of proportionality. In case this situation would be brought before the European Court of Human Rights, the court would award compensation, not for a tax in full, but for a sum that is reasonably related to the value of the property lost. And of course, the court will be hesitant to make specific calculations in this respect. I also doubt they would be willing to embark upon calculations into all Pillar 2 area, because that would just be too complex, I think, for them to handle as well. Lastly, I'd like to return to the lawfulness criterion, Now, like I mentioned, the issue of whether a fair balance was struck will only become relevant when it has been established that the interference in question has satisfied the lawfulness criterion. And there are several ways in which a rule can infringe this criterion. I already mentioned that a legal rule must be clear, it must be applied consistently, it must have a certain quality, but it's also possible that a rule breaches another set of rules. For example, customary rules, like the nexus requirement, which you talked about. If, and I say if, the Pillar 2 rules would infringe customary international law, I think there is a case that the lawfulness criterion is not fulfilled. And in that case, the mere breach of the lawfulness criterion is sufficient to determine whether a breach of property rights has taken place. No proportionality analysis will have to take place. The amount of taxes will be irrelevant. There will just be a breach of the right to property. And in fact, if such a case will be brought before the European Court of Human Rights, the mere fact that the lawfulness criterion is not met will allow the court to award a full restitution of the amount of tax paid, which is, I think, a severe consequence, especially in this area. So to summarize, I think under the proportionality analysis, there are elements which, in my opinion, point towards a breach of the right to property, but one can certainly not forget the discussion on the nexus requirement. In case the court would say, well, UTPR breaches the nexus requirement, well, then things get a lot more trickier, let's say, for the legislator. Thank you.
Thank you so much, Philip. Please keep raising your questions in the chat. After Julian Chay's presentation, we will still have 20 minutes for more questions. So please keep raising your questions in the chat, and then after I will give also the word to some of you, or just please raise your hand, because since we have 20 minutes will be okay. And the questions could be for the first 3 presentations, but also for these 2 presentations. So someone asked in the chat about bilateral investment treaties, and we're so happy to say we are also discussing bilateral investment treaties, and who best to do this than Julian, who is a very good friend, and we have been working a lot. And I think that you are the right person to discuss this topic. So Julian, please go ahead.
Well, thank you, Emma. Thank you, and hello everyone. So just to start, I'm grateful to Emma and Peter for inviting me to this panel as we explore the compatibility of the UTPR in Pillar 2 with international law obligations. I think it's a huge debate, as shown in the previous presentations. But I just want to add something somehow more fundamental before I look into the details of investment law. What I believe is that today's discussion is very interesting because, in fact, it not only deepens our understanding of the intricate relationship between UTPR and international law. In fact, there is something bigger behind this. I think it's important to highlight that today's discussion also contributes to the broader, say, conversation on international tax law and global economic governance, which is very often neglected, at least by investment lawyers or trade lawyers. So that being said, in my presentation, I will focus on investment law, which makes sense because it is closely linked to cross-border investments and M&As and activities, and therefore it's relevant to international tax law and tax reforms. More specifically, I will explain why investor-state dispute settlements, also abbreviated ISDS, could address disputes arising from UTPR implementation in a number of jurisdictions, even though ISDS is not typically designed for tax disputes. It remains possible. So for my presentation, of course, I will stick to the hypothetical scenario explained by Peter at the start of today's webinar. So I won't repeat the terms, but what I want to do is to briefly contextualize this hypothetical case in the context of reinvestments. All right. And it's a little challenging. When I was asked to reflect on today's topic, I found it's difficult to say pinpoint specific real-world foreign investors that closely match the hypothetical scenario without, of course, having access to detailed financial data and the tax structures of M&A, right? However, I believe that it's possible that some small subsidiaries or joint ventures of larger M&Es might face issues similar to those described in the hypothetical scenario. And so what I see is that, for instance, smaller subsidiaries operating in industry with low profit margins, or those that have significant investments in research and development, might have limited financial capacity. So in my reflections, I use the hypothetical scenario and I consider an investment example involving an M&E in the technology sector. As many of you will understand, this will make the hypothetical scenario, I would say, terribly realistic. So what I say is very simple. That's the following. Let's assume that we have a company called Tech Global Corp. That's the M&E in the tech sector, with a subsidiary in the country, which is country B. Subsidiary is called Tech Global Innovations, or TGI, to make things simple. So TGI is a small R&D focused company that collaborates, for instance, with local universities, research institutions, and so on. The company is responsible for only a minor part of Tech Global Corp overall profits. And here we get the foreign investor. So in my context, I call the foreign investor Mr. Smith, right? He's a foreign investor from another country, country X. He owns 30% of TGI shares, while Tech Global Corp holds the, say, remaining 70%. Now, the GLOBE proposal is implemented, and the UTPR applies because there is no IRR in this scenario, right? So Tech Global Corp overall profits, excluding TGI, amount to 100 million USD, and the tax rate for GLOBE purposes is 5%. Now, the UTPR burden is calculated as 10% of 100 million, resulting in 10 million. Now, to stick to the scenario, we say that TGI has net assets of only 1 million US. So as a result, either the other subsidiaries within Tech Global Corp must bear the additional tax burden and transfer it to TGI, or TGI will face potentially bankruptcy. So for Mr. Smith, the foreign investor from country X, this situation would likely amount to a de facto expropriation, as the value of his investment in TGI, located in country B, would be significantly impacted. But expropriation is not sure. And what I will show you is that there are many other investment standards, potentially more onerous than expropriation. And so it means there are greater risks for countries implementing UTPR. Earlier today, I heard somebody say there is very easy to demonstrate a breach of investment treaties. Well, it's always more subtle, can be more complex. That's what I'm going to focus on. So yes, given the potential breach of an applicable investment treaty in this scenario, you see that it's important to consider the relevant principles of investment law and arbitration. So in the hypothetical investment disputes between Mr. Smith and the state, potential breaches of the applicable investment treaty could arise, leading to many legal concerns. First, the applicable treaty, it is assumed lack of tax exceptions, because Otherwise, of course, no claim is possible. So that's tax exceptions in investment treaty is a topic of its own. But for the sake of the example tonight, we assume that there is no such exception. Secondly, Mr. Smith must then establish that the disputes falls within the jurisdiction of the investment tribunal by demonstrating that he's a qualifying investor. So TGI is a qualifying investment, and the state's actions in implementing the UTPR are within the treaty's scope. So the foreign investor may in fact make a number of arguments. The foreign investor may argue that the state's UTPR implementation and its financial impact on TGI constitute a de facto expropriation of the investment. It could also contend that the states breached the Fair and Equitable Standard, or FET, and violated the national treatment and most favored nation treatment standards by providing less favorable treatment to foreign investors compared to domestic investors or investors from other countries. So there are potentially multiple breaches that I will look into in a few seconds. But the very important point to highlight at this stage is that if Mr. Smith successfully proves the state's treaty breaches, he could seek compensation. So since I cannot delve into all these points that you see here, I will focus on only a few, namely jurisdiction, expropriation, fair and equitable treatment, and if we have time, national treatment. So let me start with jurisdiction. So in order to establish jurisdiction of the arbitral tribunal, Mr. Smith must demonstrate a number of key elements. First of all, he would have to prove his nationality as a country X citizen, okay, which has an investment treaty with country B where TGI operates. So this will confirm his status as a qualifying investor. And then Mr. Smith must provide evidence such as shares, certificates, or corporate documents to verify his 30% ownership in TGI as a qualifying investment under the treaty. Number three, the investment treaty must cover the period when the alleged breaches occurred. So Mr. Smith needs to show that the treaty was in effect during the breaches and that his investment was made within the treaty's temporal scope. Also, Mr. Smith must prove that the state's UTPR implementation and its effects on TGI are within the treaty's subject matter. And this may involve demonstrating the treaty's substantive protections, such as fair and equitable treatment, national treatment, and that they apply at least prima facie to the state's measures. And number five, Mr. Smith, needs to comply with the treaty's dispute resolution provisions, possibly showing evidence of some attempted amicable settlements before pursuing the arbitration. But, looking at this picture, this scenario, there is, I would say, a reasonable likelihood of establishing jurisdiction over the disputes. So we can move on and look into the potential breaches of substantive investment law. The idea is that so far, the hypothetical scenario transposed to the world of investment is very reasonable. So first, expropriation. I won't speak much about it because Philippe de Belva has already addressed the infringement of the right of property concerning expropriation in the European context. But there are some differences with the regime of investment treaties, right? So in the context of international investment law, what I just want to highlight is that Mr. Smith would have to demonstrate that the state's action significantly and enduringly impacted his investment value and lacked a valid public purpose or say non-discriminatory application to succeed. Specifically, he could argue that UTPR's implementation, say, drastically and persistently undermined his investment value, depriving him of TGI's economic benefits. And he would have to demonstrate that the effects of UTPR are equivalent to a direct taking without formal title transfer or seizure. And additionally, he can assert that the state's measures lack a legitimate public purpose, also lack proportionality or non-discriminatory application. And as you can see, I don't elaborate on that, but there are notable precedents, cases that may support this foreign investor claim. The next very important issue, and I was about to say perhaps even more important, is the issue of fair and equitable treatment. It's very important because Mr. Smith's investment in TGI may have been affected by potential breaches of this FET, particularly the introduction of the UTPR by the state. Here, it would be very interesting to think about the evidence available. I think that crucial evidence could include documents highlighting the lack of transparency or the lack of consultation during the UTPR implementation, as well as say the proof that the state disregarded Mr. Smith's interest when enacting the measure. But the point is, fair and equitable treatments might be a more effective tool for foreign investors to challenge the UTPR. The question behind the fair and equitable treatment, to make it very simple, is basically how certain states are going to implement the UTPR. The how is going to matter. The question is not just whether they implement UTPR. And so, quite logically, concerning the arguments, Mr. Smith could argue that the state's UTPR implementation disrupted his legitimate expectations of a stable legal and regulatory framework when he invested in TGI. On top of this, the foreign investor could claim that the state lacked transparency in the UTPR implementation process, causing unforeseen and detrimental consequences for the investment. There'll be some further arguments. The last one I want to mention in this context, and that makes a lot of sense, is that a foreign investor could also assert that the state failed to offer adequate due process or some procedural fairness during the UTPR implementation and in determining its application to TGI. So any lack of consultation on the part of the governments when they implement UTPR could be a problem under the fair and equitable treatment. Then the last standard I want to discuss is the national treatment. Because when we began to discuss with colleagues, that was not the most obvious standard to consider, but I think it may have a role to play. Why? Because here, the investor might also argue that the UTPR enforcement unfairly targets his TGI investments, violating the national treatment in the applicable investment treaty. To claim national treatment, the foreign investor must provide three legal arguments. First, got to demonstrate that his TGI investment shares characteristics and competitive relationships with domestic investments in the same sector, for my example, the tech sector. Secondly, he would have to prove that the UTPR's implementation unfairly impacts TGI compared to similar domestic-owned entities. And three, he must counter state arguments, potentially claiming that treatment differences are based on legitimate policy objectives or objective criteria. So, you know, all in all, the idea is that Mr. Smith's national treatment breach as a claim does have potential. But there are some other elements that would be very interesting, but for the sake of time, I skip them. There'll be certainly a good rationale to claim breach of MFN or even breach of full protection and security. Just want to save time for the remedies, because that's, I think, very important and part of our equation. So if Mr. Smith can prove the state's treaty violations, 1 or 2 or 3 or 4 under the various provisions I discussed today, then the issue of remedies becomes crucial. And so he may pursue compensation or restitution in accordance with investment law. Now, compensation is the most likely remedy in practice, means that it involves monetary damages for his losses. And what I find interesting is to reflect on how this would work out in our scenario. So for sure, in determining the appropriate remedy, the investor can refer prior cases where tribunals have granted similar remedies, including in investment disputes that involve tax measures. For instance, as we said, if his 30% stake in TGI was initially worth 300,000 USD, assuming that TGI's net assets were 1 million, and assuming that the implementation of the UTPR caused TGI's net assets to decline by 50%, then Mr. Smith's share would be worth only 150,000. And in this scenario, the compensation could be at least the difference between the initial value of the diminished, the initial value of the investment and the diminished value. So 300 minus 150. But I note for your reference that Smith might also claim compensation for lost profits and other financial harms resulting from the breach, or the breaches, which could increase the total amount of compensation sought. So I come to my conclusion and have 3, I think, very clear points to make. First, frankly, based on the hypothetical scenario and the potential breaches of the investment treaty, my initial or my preliminary assessment is that in such a scenario, Mr. Smith could prevail in an investor-state dispute settlement proceeding, if, of course, he presents strong legal arguments and evidence. Just remember that it's challenging to identify specific foreign investors or companies that match this scenario, because we lack a number of financial data and knowledge of tax structures. But they are potentially many. Point number 2, the outcome of Mr. Smith's case depends also on the applicable investment treaty's terms. So here that means the specific investment treaty that would be applied. For the sake of the discussion, I took a very standard investment treaty providing for expropriation, FET, NT, and so on, without specific exceptions. But of course, in the real world, there may be a number of variations as for the exceptions used in investment treaties, right? So the first variable to consider would be the specific applicable investment treaty. Another variable, of course, is how an investment tribunal would interpret a number of crucial provisions in the context of tax measures. Let me close on a last point. UTPR could be a game changer if it were codified into a multilateral a multilateral international treaty, and as we assume, binding on the state. We are yet to get there. Just for the sake of the reflection discussion, that could be a change in my scenario, in the scenario of investment arbitration, because in such a case, if UTPR was multilateralized, Mr. Smith's investment claim might face significant challenges that we can discuss later in the Q&A. On top of this, what I believe very important to highlight is that such a codification of UTPR would be a game changer, because the fact that UTPR would be imposed by international law might also limit the range of remedies that foreign investors could seek in an ISDS proceeding. That's it. Thank you for your attention, and I look forward to your questions.
Thank you so much, Julian. I think that you have made excellent points, and I'm not sure if the OECD has taken all of this into account, because of course bilateral investment treaty is the first thing that will come into place by investors. So I ask people to raise their hands, so they have done it, and so I will follow that order. First, I will ask to Jeff, I believe, van der Volk, and then after we will Blanchet, then Dieter, and then Vikram. Please go ahead, Jeff.
Okay, thanks very much. Nice to see you, Julien, after our years of being colleagues many years ago in Hong Kong. I just had one question in your scenario. If it were not Mr. Smith making the claim, but rather the MNE Gentech that was making the claim, how would that affect the strength of the arguments in your view?
Yeah, Julian, I will give the word to you, and then after I will go to the next speaker.
Yeah, Jeff, that's a pleasure to see you, really. The argument will not change, but the legal standing would be affected. And the problem for that MNE would be to demonstrate the direct involvement in the subsidiary. So arguments would remain unchanged. The legal standing would be more carefully scrutinized, and there could be an issue at that very time. But that wouldn't be, I would not rule out the possibility for the MNE to have legal standing, just to be clear.
Maybe I should have clarified my question. Could the claim be made by the resident company that was subject to the top-up tax in country B, that is TGI? Could it be the claimant under a BIT?
Would that claimant be a foreigner?
No, it would be the resident subject to the top-up tax. So I guess
no,
it could not rely on the BIT.
Exactly. That's the issue here. Then the clear answer is no, it's not possible. You must have a foreign element in either the individual or the entity that is challenging the state implementing the UTPR.
Okay, thanks.
Thank you so much. I will give then the word to Blanchet. Blanchet?
Hello, good afternoon. Nice to see you again, Julian. Thank you for this excellent presentation. I have a question. What is your view on a situation where, let's say, there will be no really like investment international agreement applicable, but an investor would rely on the general principle of law, let's say principle of proportionality, which is quite widely accepted in the international arbitral case law as being a general principle of law. Of course, then we don't have a stance in front of the ad hoc arbitral tribunal. We don't rely on ICDS. We need to rely on domestic courts. But I'm just thinking in terms of alternative to investment agreements. Would you think that UTPR is so far-reaching that it is possible to rely on the general principles of law directly in front of the domestic court, or rather it's something hardly to imagine in practice, and this question is not practical? And one question regarding do you think that arguments regarding damages, determination of damages, may be used by respondent states as a counter argument or counter claim at the jurisdiction phase or even the merits phase, and therefore to try to convince arbitrators to deny the jurisdiction?
Thank you, Blažej. Can I just ask you to clarify your second question, because I'm not sure to get it. Why would the question of damages be something to be discussed or to be used by the responding states in such a dispute?
Oh yes, so in the case of qualified domestic top-up tax, that it's pretty clear, because if one country doesn't use that option to implement at least 50% of taxation, then another country will apply income inclusion rule. So there is some argumentation according to which it doesn't make sense to rely on investment treaties, because if not one country tax, then another country tax. So if you look at the consequence of Pillar 2 rules altogether as an interconnected mechanism, you will need to end up anyhow in taxation, in effective taxation up to 15%. With UTPR, I understand your confusion, because with UTPR the situation is quite clear that that the country effectively imposed taxation, and so you can say that the quantum of taxation is a damage, is the quantum of damage, of course subject to quantification. But Pillar 2 rules will apply only to multinational groups with very high threshold, more than 700 million euros. So in your example with Mr. Smith, let's say that we don't have Mr. Smith, but we have local subsidiary, which is, I think, a bit more realistic. Then you can say, okay, we understand that UTPR may lead even to expropriation of that entity, of the subsidiary, but its parent, which is not subject to 15% of taxation, therefore UTPR is triggered, is multi-billion US dollar company. So looking from the perspective of the connection between extremely profitable parent and the subsidiary subject to UTPR, this argument could be used, or maybe it is very weak argument from your experience and observance of the arbitral case law.
Look, I think this is something certainly very interesting to explore further, but my immediate answer would be that an investment tribunal will not look at the overall perspective, purpose, design of the UTPR in multiple jurisdictions. A tribunal established under a given investment treaty will have a mission, which is to ensure that this investment treaty rights granted to a given foreign investor are duly respected, right? So it's very likely to only focus on whether there is any damages that can be assessed under one or more standards, one or more investment standards. And from there, we'll at some point shift to the issue of the calculation of the compensation. I don't think an investment tribunal will look beyond that. That seems to me very unlikely. Although I get your point that the responding state could try to build the line of defense with this. But you know, we will have to more carefully look at the number of investment disputes dealing with tax matters. And I doubt, even in the recent past, that any investment tribunal had paid attention or given any weight to this kind of considerations. So I'm afraid the answer would be, for now, unlikely. Okay, but subject to perhaps further investigation. On your first question, I would be again skeptical. I'm not sure. Well, that's the kind of situation where we cannot rule out the possibility for a given state or given jurisdiction in a given state to take into account the general principle of international law, but there is no similar or relevant cases that come to my mind. I'm trying to very quickly go through the few international related cases that I came across in my career, whether in India, France, Switzerland, Hong Kong. I don't see anything that rings any bell here. So I wouldn't say no, but very unlikely in my view.
Thank you so much, Julian. I believe I give the word now to Dieter. Dieter, you also had in the chat one question for Philip. Please go ahead. Dieter Bettens.
Yeah. Hello, can you hear me? Yeah, great. So I actually had a question for Vikram and also a question for Philip. So maybe the question for Vikram was on the treaty compliance of the IIR and the UTPR. So you mentioned a couple of articles, and I also acknowledge, or I agree, that especially the UTPR is at least at tension with tax treaties. But my question is with regard to the arm's length principle in Article 9. Could you maybe make an argument that the adjustment that could be applied under the UTPR is not really, or it's more, it does not really have anything to do with the arm's length value of the transaction, as in it does not dispute that the transaction is at arm's length, or that the value of the transaction should be different to be at arm's length, but rather it accepts that value, but then afterwards makes an adjustment based on other considerations, for example, abuse, if that's the goal of Pillar 2, which is also a little bit disputed, but, or for example, tax competition concerns. So could you maybe say that there is no infringement of Article 9 because the UTPR or the IIR is not really concerned with the arm's length value of the transaction? So that's my question for Vikram. Maybe I also ask the question for Philip, which is actually also something that Vikram mentioned and also the last presentation touched upon. It's actually the question, so you mentioned the lawfulness criterion, that could also be a problem and could lead to an immediate breach of the right to property. If, for example, the nexus criterion would be, or double tax treaties would be breached. So if you would indeed introduce a multilateral convention or in bilateral tax treaties, a UTPR rule or a provision that says that the UTPR does not infringe tax treaties or anything else, would that change your opinion towards the lawfulness criterion breach? So in the last presentation, we saw a little bit on that in concerning bilateral investment agreements, but is the answer the same for a right to property or not? So that are my two questions. Thank you.
Thank you. And let me give first the word to Vikram and then after to Philip. Vikram?
No, actually, I wanted to ask a question to
I know.
Julian,
So I will
but
give
it's
you the
fine.
word
It's okay.
afterwards.
No. So thank you, Ditya, for the question. Basically, you have to go back to Article 9 and you need to ask yourself the question, what is the scope of Article 9? Well, basically, you can make, again, arguments for and against. But what we've written in our paper in World Tax Journal, but we've put arguments for and against, where we basically said the scope of Article 9 is not absolutely well defined. At least from our point of view, Article 9 applies mostly to related party transactions. And you need to make a difference between the UTPR and a general interest limitation rule, which you find, for example, in BEPS Section 4. A BEPS Section 4, a general interest limitation rule, it basically applies across the board. It applies to payments, whether they are made to related parties. It also applies to payments which are made to unrelated parties. There's an interest deduction which has been designed. So if you have a financing transaction, and even though the interest payment is at arm's length, if a BEPS Section 4 kind of rule applies, which basically is a rule which applies across the board, it applies to payments made to related parties, unrelated parties. Well, in that in that sense, the BEPS Section 4 rule, of course, it goes beyond the arm's length principle, but that rule doesn't really need to be tested with Article 9 itself, because it does not fall within the scope of Article 9. So in the paper that we wrote in the World Tax Journal, basically we've come up with a new argument, and we've basically tried to demonstrate that the scope of Article 9, basically Article 9 applies to all related party transactions, or let's say it applies to transactions among associated enterprises. So when we have the GLOBE rules, which also apply to associated enterprises only or to related parties, well, in that particular scene, from that point of view, we are trying to make an argument that it falls within the testing scope of Article 9, and because it falls within the testing scope of Article 9, it we use Article 9, which is essentially a profit allocation mechanism. So Article 9 deals essentially serves as a profit allocation rule, and we say that this goes beyond the arm's length principle, and hence a potential conflict could arise. So it all depends on the scope of Article 9, and the boundaries are not absolutely clear. So for us, you need to make a difference between a rule like the UTPR and a general interest limitation rule. General interest limitation rule does not conflict with Article 9, at least that's my feeling. But a UTPR, which applies only to related party transactions, only to associated enterprises, falls within the testing scope of Article 9. Of course, we can have back and forth arguments on this, definitely, but that's the view we've taken. So just on this, coming back to the bilateral investment treaty side with Professor Julian Chase, it was a very interesting presentation. And, I just wanted to, I think my question was answered, but I just wanted to point out that once again, the need for a multilateral instrument. Because if you have a multilateral instrument, which basically crystallizes the application of the IIR, UTPR, or the QDMTTs, well, then in that case, you see the frictions go away with tax treaties. The frictions go away or are reduced to a considerable extent under bilateral investment treaty space. So I still don't get it, why a multilateral convention is not being opened for Pillar 2 purposes. Is it because of laziness or because of what? I just don't get it, because whenever I read some public comments or statements, everyone says, oh, there's no political momentum behind a multilateral convention. But there is clearly political momentum for introducing the rules. But why is there no political momentum behind opening a multilateral convention? I still don't get it. Why a Pillar 2 multilateral treaty is not open, and all these discussions which we are having are just neutralized. And the GLOBE rules can then be peacefully implemented, and they apply across the world without any problems. So yeah, that's it.
So I guess I would just we park 1 second the question of Vikram, why we do not have a multilateral, because there are two questions for Julian. One is the one of Vikram, and one is one Attorney General. But let me give the word to Philip to reply to the question of Dieter. And then after we'll give the word to Julian to reply to Vikram's question and to the Attorney General question. Please, Philip, go ahead.
Yes, thank you, Irma. Well, Vikram did most of the work for me, I think. It's like he says, and like Julian says, an international treaty would be a game changer on so many levels, and it would be the most obvious solution for answering several legal questions regarding Pillar 2, not only regarding international customary law, also regarding tax treaty law, but also regarding the right to property. Because if the nexus problem would be solved by adopting a multilateral treaty, that would also eliminate problems with the lawfulness criterion on the right to property. So that's let's say the most difficult part regarding the right to property would be solved by adopting such a treaty. And in an article with Luc de Broe, I've argued that there will be several ways to adopt such an instrument, either by adopting a standalone multilateral instrument that codifies the Pillar 2 legislation, or as I call it, it would be alleviated to the level of a treaty, let's say. And the other way of solving this issue would be to insert a separate chapter on Pillar 2 into the existing MLI. That would solve a lot of things. Now, naturally, merely inserting the entire framework into the treaty would not shield the rules from being tested against the right to property, but it would solve the lawfulness part. it would not have such an impact on the proportionality analysis as such, but it would certainly solve the last problem. And I think that's the gravest problem of the two. So it's a warm call from my side to indeed just codify this. And then indeed, like Vikram said, we wouldn't be having this discussion.
Yes. Julian, please, you have two questions. The one raised by Vikram and the another one in the chat. So would you
thank
like
you.
to? Yeah.
Well, I'll try to combine the two in one answer. Okay. Look, yeah, I'm reading the question at the same time. It's a long one, so I don't read it out, but it's all about the potential codification of UTPR into a multilateral treaty, right? Or even regional, anything. And yeah, it would have huge implications. One has to be clear about that from the investment perspective and from the pure legal perspective, I should say. If we talk about an international treaty obliging states to implement UTPR, then it means that states implementing UTPR would be considered using a legitimate exercise of their sovereignty, of their regulatory power to do what? Well, fundamentally to comply with international legal obligations. This is a radically different legal framework and legal scenario. So that would become very difficult for my Mr. Smith, right, the foreign investor, to challenge the state for expropriation, because by definition, even if something negative happen, affect the foreign investments, it is the result of the exercise of regulatory powers to comply with international law. So unlikely to find an expropriation. Also very interesting, think about the implications for national treatments and most favored nation treatment. I find it's very interesting to consider because, again, if UTPR is imposed by international law, then it means that UTPR would have to be applied equally to all qualifying entities regarding of their nationality, origin, so domestic or foreigners, like international law basically would oblige the states to treat in a no less favorable manner, both domestic and national. So again, in that scenario, I don't see how there could be a breach of NT and or MFN. And so you see, if you think about it, less, I mean, we think in terms of probability, which is always a bit risky for lawyers. We are not doing mathematics, but it would be less probable for the foreign investor to demonstrate a breach of expropriation, national treatment, MFN. But I come to the last point, Emma, which I find wonderful from the investment perspective. Fair and equitable treatment is the one that will remain very important, because remember when I say, when I explained fair and equitable treatment, I told you it's not so much about what the UTPR does. It is about how it is being implemented. And here, there is a difference, because even if the UTPR was an international norm, depending on how a given state would implement it, may amount to a breach of the fair and equitable treatment. So for instance, if the implementation was sudden, radical, without consulting foreign investors, without informing foreign investors about potential significant changes in the tax environment, that would be sufficient to have a breach of FET. But yes, when I close on the remedies, because even if there were a breach of equitable treatment, then the next question is the remedies, so compensation. The point is that if UTPR was internationalized, we have some examples, not so many, but a few examples of investment tribunals that are reluctant, even if there is a breach, to award significant compensation, right? So that's, I think, a point that clarified this very good question. Yes, UTPR multilateralization would be a solution for many reasons, in particular vis-a-vis potential clashes with investment treaties, but there remains still some little issues here and there.
Let me ask one question that was raised on the chat. Assuming no multilateral treaty, I guess that Sorka wanted to, she meant. What about the other side? So we are discussing what investor and the arguments that investor can provide, but what about the state? Is there any way that the state can get a legal defense in this dispute? And we have to go through all sides. So hopefully you can also help us with the other side, the side of the state. Julian, for you?
Yeah. Look, for today's seminar, we have taken a view to take the challenging view, which is to show that there are risks associated with UTPR. I'm not here to defend or make the case of foreign investors. Things have to be understood very properly. By showing the risks associated with UTPR implementation, we are helping out the states, right? That's how I see my presentation. I hope it's clear for everybody. Although as a good lawyer, acting very often in proceedings, I'm very happy to work for one side or the other. That will depend on the client. Joke apart, look, I would have to redo the presentation. Yes, there'll be a number of arguments that states could do to justify their not just the UTPR implementation, but I would say the adequate, appropriate, and informed implementation of UTPR. But we would have to have another seminar to discuss that. My very sincere assessment is that having very carefully considered all the arguments on the two sides under up to 6, 7, 8 different provisions, the balance is in favor of the foreign investors. That's why when I was preparing for today, my concern was more to think whether there would be so many foreign investors affected by these kind of measures. And the more I've been looking around, the more I've been talking to a few lawyers in Hong Kong, the more I came to the conclusion that yes, it's realistic. If I may add just one small thing, Emma, I played the game to try to calculate the compensation in the scenario designed by Peter, a very realistic scenario, as I said. And we have to look at the number. They are not very high. 150,000 US in compensation for foreign investors. It's very, very small in the world of investment arbitration. Just to give you an idea, on average, investment compensations are around 300 million US dollars, which means, and that's very important, in many cases, investors will only sue states if there is a lot at stake. Now, when I was thinking about that, something was telling me, well, it's not very likely to have so many Mr. Smith suing the same states for UTPR implementation. But here, then I thought one has to be very, very careful, because there are also examples of disputes which are really relatively small in size, but that may involve small investors that went bankrupt and they have nothing to lose. So, and I will close here, should there be many Mr. Smith in the same jurisdiction because the state decides suddenly to implement UTPR, should also, I wanted to mention that, these many foreign investors group together and decide to have a sort of mass claim. Think about, consider the case of 30, 50, 100 foreign shareholders who are victims of this UTPR, and they decide to fight together, where you get something that's very realistic that we have seen in a few other instances with mass claims, many small bondholders deciding to challenge a state altogether, and that may have a strong case.
Thank you so much. Philip, you have, because I have to give my presentation, so you will have 2 minutes to reply to Luisa's question, and then after we go to my presentation. But you can keep discussing also in the chat. Please, Philip, go ahead.
Okay, I will briefly answer it. So the question is, whose property rights would be violated? Well, basically, it's the entity on which the tax is imposed. This property is being taken away by the state, so that would be the entity that would be entitled to complain before the court. A second question relates to, what if the UTPR applying jurisdiction is non-European? That relates to access to the European Court of Human Rights. First of all, it should be noted that you as an affected taxpayer can only access the European Court of Human Rights after you've exhausted the domestic remedies that are applying to you. So it's only in the second step that you reach the court. Second remark is that the convention only applies to persons falling within the jurisdiction of the state. So it's more of a European-centered document. Now, it should be mentioned that there are other human rights instruments outside of Europe that can also apply, of course, and they also have their own judicial bodies. I'm thinking of, for example, the Inter-American Court on Human Rights, and I think there's also an African Commission on Human Rights that can also render decisions. Now, I'm not an expert in those bodies, but I know that they frequently rely upon case law rendered by the European Court of Human Rights. So I think that the findings regarding fair balance, proportionality and the like, they, I think, apply in full for them as well. I think I only used 1 minute, Irma, so...
You're perfect on time because I gave some of my time as well, but I have a very short message. So that would be okay. And perhaps if there are more questions, hopefully we will have still 1 or 2 minutes or 5 minutes for more questions. So let me first share my presentation.
Yes, so I take the role as a moderator.
Yes, you do.
The floor is yours. We are very much looking forward to your comment.
So, so this is the final one. We have discussed the international law, and we have also discussed the tax treaties, the European Court of Human Rights. We have discussed also the investment, and there is a lot of what we say concerns regarding the introduction, the UTPR, that is one of the parts of the pillar 2. And one of the things that the starting of my presentation in this case is, if we are saying, and I remember Peter started like the countries unable or unwilling to implement pillar 2 should publicly oppose to the pillar 2. But the question is, can they do that? And that's a problem, because in this standard of tax good governance, and I also have in recording, 1.5 years ago, in December 2021, we did organize a global tax symposium, and I asked to the European Commissioner Benjamin Angel at that time, is pillar 2 going to be included in the standard of tax good governance? And he said yes. And now we have the directive of pillar 2 has been approved. And of course, all the discussion on the directives, but I am focusing only on the standard of tax good governance and what happens if pillar 2 becomes part of this standard of tax good governance. But in order to do that, I first need to explain what is this standard of tax good governance, because I do have a Jean Monnet chair on this topic to raise awareness. So I'm paid by the European Union in a Jean Monnet chair to raise awareness on this standard. And I'm not very positive about it. So first of all, we see that in taxation, there is in the European Union, there is a role of the European Union in the formation of international law, but also in the tax developments. And the aim is, of course, to promote fair taxation and also to facilitate the implementation of the BEPS implementation, not only within the EU, but also international. And when you see that, and you see this is the goal. So we need, the European Union is saying we need to have an important role. We need to support all the international tax developments, and we need to go further than. One example of that is, for instance, the Anti-Tax Avoidance Directive 2 that was applicable to non-European countries. And at the same time, we see now that with this standard of tax good governance, that has been kind of the carrot and the stick that with the European Union to work with this. Carrot and stick, I will explain why. Because this standard states, and it was approved in 2018, and then in 2008, and then in 2018 was revisited, includes and promotes the parties recognize themselves to commit to transparency, exchange of information, fair taxation, and since 2018 to comply with the base erosion profit shifting minimum standards. The question of this standard of tax good governance means that in this case, in the European Union, was not only about complying with the BEPS, so not only participating of implementing the BEPS for minimum standards, but also receiving a positive review. And you remember that these BEPS for minimum standards have been revised in this peer review process that the OECD has initiated. And therefore, in this, the EU went a little further than, not only say you countries have to commit to implement the BEPS for minimum standards, but you need to have a positive review. And why is as a carrot? Because in a way, this standard has been used and introduced in different agreements, for instance, framework for cooperation, but also for trade agreements and also for economic partnership agreements, also to give EU funding for projects in other countries. So we are talking about non-European countries. So this is the carrot. Let's follow the EU standards. I will conclude with you that I will introduce in a trade agreement, good for all. We will also give you EU funding, but we also have the stick. And the stick means that if the country refuses to introduce this, then there will be an appropriate response, and this response could also be scrutinized under the EU listing exercise. So the stick is, if you don't do it, then we will have in the list of non-cooperative jurisdictions. When we look at that, in 2020, still tax good governance in the EU and beyond. So it means that it's the EU who is deciding what is going to happen within the EU, but also what is going to happen beyond, and still we follow that. And what I mentioned to you, what happens if Pillar 2 goes next to transparency, BEPS for minimum standards, exchange of information, and fair taxation. So what happens if this Pillar 2 is in the EU standard of tax good governance? We know how the approval of the directive on Pillar 2 came into place, and also the kind of negotiations behind with two countries of the European Union that everyone knows about it. And in a way, there is already the directive has been approved with a lot of political discussion, commitments, and so forth. And the reason why they say is that, well, the EU wants to be a front runner in applying the OECD global agreement on Pillar 2. So this also says, well, the EU will help to apply this pillar global agreement on Pillar 2. What is interesting to see is that there is also this platform for tax good governance. And there were some discussions there that I will mention to you on regarding this political or global agreement. In principle, we know the questions of, for the ones who know me, know about legitimacy, inclusiveness, and fairness. And of course, this is a political agreement. And we know already how complex this political agreement is, because even we do have the political agreement, only the model rules, only the administrative guidance, all the documents published afterwards gave all the comments to this political agreement. So we agree on a higher level. And know by all tax jurisdictions. We already know that Sri Lanka, Pakistan, Nigeria, and Kenya did not commit to this political agreement of the BEPS inclusive framework. Regional organizations, ATAF, CARICOM, and developing countries have also saying, is this part of the global fair deal? So there are questions regarding the legitimacy of this Pillar 2. The legitimacy of this agreement is really an agreement for everyone. Is this part of the fairness? And at the same time, we also see, for instance, that Colombia has started a discussion on whether to have a regional approaches. And we also see the part of the UN resolution that was approved in the General Assembly with a UN framework of instrument on international tax cooperation. So the question is, if we ask, and the Pillar 2 is going to be in this EU standard, what happens then? can the countries, and then I go back to Peter's question, can the countries publicly oppose because they are unable or unwilling to implement Pillar 2? Can they do it? And you may say, well, you are exaggerating because what happens with these agreements? I mean, countries may decide or not decide to do it. But having it there and having it in part of this standard of tax good governance, hopefully the European Commission can be a little aware of this, and the platform of tax good governance means that it's introducing something that there is a lot of discussion on it, that we do not have legitimate, that doesn't have the global fair deal, that is not inclusive, but still we are asking the countries to do it, because at the end of the day, you not only need the trade agreements, the economic partnership agreements, but even you need EU funding. And that's very important. So you need funding for bridges and so forth. So in the summary of the discussions in December 21 was interesting because one of the members of the platform, and these discussions are available for everyone in that link, it is difficult. And in this case, one of the members of the platform mentioned, and he said, it is difficult to understand whether the inclusive framework works on the basis of consensus among its members or not. So there was the question, is the discussion based on consensus, yes or not? And international fora such as the United Nations, this is one of the members of the platform, and you may imagine that this is one of the civil society who is claiming for a more role on the UN of the United Nations. So the United Nations should be the one. What is the response of the European Commission on that, of the chairman of this platform of tax good governance? It is true that not every state actively approved these rules, but inclusive framework operates by consensus and not by unanimity. And then the question is, what type of consensus? And is this consensus means we did have a political agreement? We know how the model rules, the administrative guidance, how much time it took to even try to make these changes, to approve that. So this is a real consensus, or it's kind of a negotiation where the strongest party will be having an important role. And then the question is, if it's included, what are the consequences? Can a country still be in the blacklisting? Are countries still free to implement or not? And sadly enough, we see also a country like, for instance, Costa Rica, which became a member of the OECD, became a member of the BEPS Inclusive Framework, who also, even with one tax treaty, decided to sign the multilateral instrument. But now, this country, Costa Rica, is in the blacklist of non-cooperative jurisdictions in the EU. So then what are we asking to the countries? And to finalize, I give you two examples. The first one is Philippines. Philippines was a country that at the moment of the BEPS Inclusive Framework, they decide, and at the time Kim Jacinto Henares was in the tax administration, and they decide, we are not gonna be part of the BEPS Inclusive Framework. They were in the discussions, they decided it's not good for us, so we are not gonna do it. However, in this agreement between Philippines and the EU, there is an Article 12 of good governance in the tax area. So what happens with Philippines? They ask to the OECD to be reviewed for Action 5, for the HAL for tax practices. Because of course, remember, the standard of tax good governance is not that you only commit to the BEPS for minimum standards, but you receive a positive review. And then we have the new one, that is the EU, African, Caribbean, and Pacific countries that has a negotiated agreement. So still are the ratification in process, but there is been negotiated. They also say there's good governance in the tax area. That includes, in this case, including transparency, exchange of information, and BEPS for minimum standards. But the question is, for instance, this ACP, this new post-Cotonou agreement, still have a lot of problems regarding the legitimacy, but also the willingness of the EU countries to approve this. In a way that, this is my final comment, South Africa decided we are going to withdraw from the OACPS, so the Organization for African, Caribbean, and Pacific States, and we are not going to be longer interested in this agreement because we think that we can do directly something better. So the question to you is, are they, or can the countries still be publicly opposed to the Pillar 2? And with this, I will conclude my presentation.
Thank you, Irma. So looking at the chat, or raise your hands if you have any questions to Irma. We still have 2 to 5 minutes, so don't worry. I don't see any hands. I don't see any specific questions for you, Irma, in the chat.
No worries. I'm very happy that we already have a lot of questions and we have still 2 minutes. So whatever, any other question is also fine. Whoever has an urgent question, sorry, Peter, you are the moderator.
Yes, no, just one last comment and then I hand over for you to the final remarks if there are no questions. I mean, what I have learned today, and I've learned a lot, is that we need to take these international obligations seriously. And I want to remind, maybe also the OECD, because they might listen at the later stage, that in the OECD convention, not in the model convention, but in the convention, the founding document of the OECD, it's in the preamble that, they should follow existing legal obligations. And now we put countries at risks. And I think that's very dangerous. And I hope that in the next weeks, we get some more information from the OECD of how they want to address the issues raised today, because most of these issues have not been addressed by them. The treaty part, the tax treaty part, has partly been addressed, but I think there we also should have a more detailed discussion. So from my side, thank you all, but I hand over to Irma for the last comments. Thank you.
Thank you so much. And as you see, we have tried as much as possible to bring different views, different perspectives, different areas of law as well. And this video recording will be also available. And we will try to ask the speakers for the permission to share the slides. Will be in the GlovTaxGov. More interesting, I think, that just keep in all the activities that we are having. And just to say, because I mentioned this Global Tax Symposium where in 2021, so there you can also see the recordings. And for all of you, have a nice afternoon, a nice weekend. And I think that I'm very happy to see so many familiar faces here. So thank you so much for being here.
Thank you to all the speakers. Again, Julia, Philip, Vikram, Sunil, thank you. It was a great presentation and I highly enjoyed it.
Thank you.
Thank you so much, everyone. Bye.
Thank you all. Goodbye.
Bye.
Bye, Emma.
Bye,
Peter.
Julian.